高庭法官强调，塞沙迪身为公众人物，应该作为表率，因此坐牢、鞭刑和罚款的刑罚是合理的。你好，欢迎收看 Kinitv 快报，我是叶思瑜。同名党麻坡国会议员塞沙迪去年11月因为洗钱、串谋失信和滥用资金罪名成立，判处监禁7年、鞭笞2下和罚款1000万令吉。法官阿兹哈在昨天出炉的判决书中强调，法庭有必要向社会发出明确而且严厉的警示。加上塞沙迪是受年轻人崇拜的国会议员，法庭因此有必要采取更高的标准。法官补充，塞沙迪是首犯，而且还年轻，还有时间弥补自己犯下的错误，并从中汲取教训。塞沙迪在担任土团党青年团团长期间，失信受委托保管的100万令吉，以及滥用12万令吉选举资金，结果罪名成立。塞沙迪随后向上诉庭提出上诉。乌青团长艾科玛呼吁首相安华撤换旅游部部长张庆信，但国大党青年团却跟艾科玛划清界限。国大党青年团团长艾文表示，艾科玛的言论不代表国政青年团的立场。艾文接受当今大马采访时说，艾科玛的言论只是他的个人看法。艾文说，国政青年团不曾开会讨论张庆信在内阁中的职位问题，而且国政青年团已经将近18个月没有召开任何会议了。吉隆坡市政厅最近接连取缔中英文招牌，引发张庆信和艾科玛等人爆发口水战。也是国政青年团团长的艾科玛炮轰张庆信不懂法律和民情，但张庆信却反击艾科玛散播种族主义思想，而且言行举止令巫统蒙羞。艾科玛随后挑战张庆信和他公开辩论，并建议由行动党日落洞国会议员雷尔取代张庆信担任旅游部部长。随着国内水灾情况逐渐恶化，首相安华今天下令冻结内阁成员的年终假期，并指示正副部长巡视灾区。截至今天早上，吉兰丹、登嘉楼、吉打、玻璃市和雪兰莪多个地区传出灾情，其中吉兰丹最为严重，已经有6万人紧急撤离。当局还已经把吉兰丹和登嘉楼列入危险水平。另外，马来西亚铁道衔接公司 MRL 回应外界看法时，承认东海岸铁路项目确实引发了部分地区的水灾。MRL 发文告承认，洪水是由东铁施工引起的，而 MRL 会承担起责任。不过 MRL 也强调，并不是所有东铁沿线的洪水都是因为施工造成的。摘离苦不堪言之际，吉兰丹行政议员的言论却引起众怒。Astro Avani 报道，掌管旅游文化的行政议员卡马鲁丁昨天表示，季风期间的水灾可以打造成旅游季节，并且拿水上冲浪和季候风传统美食来推广吉兰丹的旅游。对此，自由今日大马引述网民留言，炮轰卡马鲁丁愚蠢荒唐。报道表示，网友嘲讽，如果愚蠢可以变成钻石，这些人已经是百万富翁。也有人质疑，这些人如何当选为人民代议士？你有受到水灾影响吗？你对丹州行政议员说水灾可以成为旅游特色的建议有什么看法呢？欢迎留言告诉我们。我们也希望你点赞和转发 Kinitv 快报，给更多亲友一起收看。另外，配合当今大马成立25周年，11月30号之前订阅或更新当今大马配套，就可以享有25%折扣。立即点击资讯栏里的链接，或扫描荧幕上的2维码来获取特别优惠。彭亨州议会今天提呈彭亨2025年财政预算案，但关丹多个地方却出现批评政府的横幅，当中包括指责州政府的国政和行动党背叛人民，拒绝为在野党选区人民提供拨款。不过，彭亨行动党主席李正贤相信，这些横幅是在野党或他们的支持者做的。 李正贤回应，在野党如果有不满，可以在州议会里提出看法。他还说，以前行动党身处在野党时，都会在州议会或记者会上争取拨款，不会用偷鸡摸狗的方式来表达意见。安华出国访问的费用引发争议，土团党主席慕尤丁嘲讽安华左闪右避。对此，巫统最高理事洛曼昨晚在社交媒体发文反击慕尤丁，要慕尤丁先照照镜子，尤其是设法说服他的女婿回国面对贪污指控。洛曼表示，慕尤丁还需要先处理好纠缠他的建威基金滥权案，并且集中精力处理土团党面对的所有案件。感谢你收看今天的 Kinitv 快报，别忘了订阅 Kinitv 的 YouTube、Facebook 和 Instagram。最后，我们有2则由自由今日大马赞助的影片，内容是沙拉越石油和天然气勘探权的介绍。影片当中观点不代表本台立场，想知道完整内容，请浏览自由今日大马网站。
OMO Oil Mining Ordinance sudah ada 1958. Dia tidak di-repeal. Bermakna undang-undang itu masih wujud di mana Sarawak ada mempunyai sedikit sebanyak kuasa dari sudut mining, dan oil dan gas ni adalah industri mining.
The state of Sarawak in Malaysia has been embroiled in a long-standing dispute with Petronas, the national oil company. At the heart of this debate is which of them owns the rights to oil and gas resources found on the continental shelf of Sarawak's coast.
The Queen in Council in 1954 telah mengagiskan ini boundary Sarawak. Jadi kita punya boundary is still within continental shelf.
The issue is rooted both in Sarawak's unique history and in the Petroleum Development Act in 1974, which grants Petronas exclusive ownership of all onshore and offshore petroleum resources throughout Malaysia. However, Sarawak also claims a right to resources off its coast, tracing its right to the state's Oil and Mining Ordinance of 1958 and a colonial order that predates it. The state asserts that in 1954, an order by Queen Elizabeth II expanded Sarawak's boundaries to include the continental shelf. According to Sarawak, an extension of up to 200 nautical miles from its boundaries existed when Malaysia was formed in 1963. This disputed area in the South China Sea is rich in oil and gas. It holds some 60% of Malaysia's known reserves and is essential to the country's production of liquefied natural gas, which forms a significant part of the national economy. Recently, Sarawak has demanded a greater share of the revenue derived from these resources. The state argues that the 5% royalty payment prescribed by an agreement entered with Petronas is not fair compensation given the scale and value of the resources within its boundaries. Former Petronas chairman Tunku Razali Hamzah disagrees with Sarawak's stance, saying the matter was not even discussed when the 1963 Malaysia Agreement was drawn up. Tunku Razali argues that Sarawak should honor its royalty agreement with Petronas.
All that we want to make sure that there is no quarrel between the states and the federal government. So we make sure that the payment is the same for everybody, whether you have oil or you don't have oil. But if you find oil, we'll give you 5% of the value of the oil. And who formulated this? It was Rahman Yaakob after he met the cabinet in Sarawak. And we discussed that with all the state governments after referring to the federal cabinet, and they agreed that is the best way to go.
Rahman Yaakob negotiated and agreed that 5% goes to Sarawak.
I mean, you can't go back and forth, you know. An agreement is an agreement, isn't it?
The Territorial Sea Act 2012 was introduced to comply with the United Nations Convention on the Law of the Sea, which Malaysia joined in 1982. UNCLOS defines a 200 nautical mile limit as applicable to a sovereign nation, in this case Malaysia, not its individual states. Sarawak also relies on the federal constitution for support.
Dalam perlumbaan kita kata, boundary cannot be changed unless with the consent of DUN, express consent, dan Conference of Rulers. Jadi kita punya boundary is still within continental shelf.
Sarawak contends that neither of these conditions have been met, rendering any changes to its boundaries unconstitutional. Maritime lawyer Liu Tek Huat, however, offers a different perspective. He suggests that the term continental shelf remained undefined in 1954.
Sarawak claims that the 1954 Order in Council extends its boundaries to include the continental shelf, which it says go up to 200 nautical miles from the edge of its territorial waters. But the 200 nautical miles length is not specifically stated in the Order in Council itself.
According to Liu, the term continental shelf was defined in the United Nations Convention on the Law of the Sea, which Malaysia inked in 1982 and ratified 4 years later.
The right to the continental shelf of Malaysia's coasts, including Sarawak's, belong to the entire nation. On that basis, the Petroleum Development Act of 1974 and the Territorial Sea Act 2012 are good law.
Clearly, multiple issues arise touching on historical boundaries, state rights, and federal authority. Unless determined with finality by the courts, any dispute between Petronas and Sarawak will likely remain unresolved. Perhaps the solution lies in a fair long-term arrangement respecting, on the one hand, the right of all Malaysians to shared resources, and, on the other, Sarawak's own rights, premised on its history as well as current and future needs. Danish Raja Reza, FMT News. A principle relied on by the International Court of Justice in the Batu Putih case may hamper Sarawak in its claim to oil and gas resources in the South China Sea. Former Law Minister Zaid Ibrahim said the effectivities principle may defeat Sarawak's claim to rights over the continental shelf off its coast.
Under this principle, the court may look at whether Sarawak exercised actual authority over the area in question. This involves inquiry whether Sarawak has displayed state functions over the continental shelf rather than simply making a legal claim to it.
Zaid said the ICJ had in the Batu Putih case acknowledged that the island historically belonged to the Johor Sultanate.
Singapore built a lighthouse on Batu Putih in 1851 and had conducted continuous naval operations in the area for many years. Malaysia's failure to protest and assert its own sovereignty over Batu Putih was seen by the ICJ as an acknowledgement of Singapore's sovereignty.
Zaid also said Sarawak's failure to challenge the validity of the Continental Shelf Act 1966 and the Petroleum Development Act 1974 may work against it in court.
Sarawak did not dispute the legality of these laws for a long period of time. In fact, Rahman Yaakob, Sarawak then Chief Minister, was heavily involved in negotiations that led to the passing of the PDA, Petroleum Development Act. Sarawakian MPs in Parliament voted to pass the bill into law, and the state has received substantial sums in royalties for 50 years.
A battle is brewing between Petronas and Sarawak after the state laid claim to all oil and gas resources on the continental shelf, challenging Petronas's claim, which is premised on the Petroleum Development Act 1974. Sarawak Premier Abang Johari Openg recently said he is prepared to take the case to court if necessary. Danish Raja Reza, FMT News.